Nante Zazulaika is my name. I am a Deputy Registrar in charge of ADR. ADR in full is Alternative Dispute Resolution. We have a registry now that is in charge of coordinating ADR mechanisms in the judiciary, and I work in that registry. ADR is one of the best dispute resolution mechanisms that we have found to be. We want to encourage people to embrace ADR. ADR encompasses mediation and plea bargaining. I spoke about mediation in my first clip, and I said mediation applies to civil cases, land cases, and family cases. However, there is an ADR mechanism that we apply for criminal matters. It is called plea bargaining. Plea bargaining is a mechanism where an accused person who has committed an offense and is very sure that he has committed it appears before the state attorney. The state attorney usually is the lawyer for the government and represents the complainant. So this person who has committed the offense appears before a state attorney and informs them about their will to accept the offense that they have done and that they want to own it up. The moment the state attorney is notified about that, they call the complainant who filed the case in court to come, and they sit on a table and agree on what it is that they want the court to do. When this person is called, the complainant sits with the accused person, and the lawyer for the accused person can also be around or may be around, and also the state attorney. They sit down to bargain and negotiate on the sentence that they feel or think should be deserving in a particular case. When matters come to court, we don't only look at the offense that has been committed, but we also look at the circumstances under which the offense has been committed. So when a person appears before the state attorney and they negotiate, they usually come up with an agreement. When they have an agreement, which is reduced into writing, it is presented before the judge or the judicial officer for confirmation of that sentence. When the agreement comes to the judicial officer, they have two options: either to accept it in totality or reject it. When they accept the agreement and they endorse on it, it becomes the judgment of court. For instance, if it is a case of murder and both the accused person and the complainant have agreed that let the accused be sentenced to 10 years of imprisonment or 15 years of imprisonment, the duty of the judge is to look at the nature of the offense, the circumstances surrounding the commission of that offense, and the judge will see whether to sanction that which the parties have agreed on or not. When the judge chooses to sign on that document, that agreement becomes the judgment of court. When the judge finds that they're not comfortable with the judgment, with the decision or sentence that the parties have agreed on, the judge can ask them to go back and renegotiate. Plea bargaining is not meant to just give handshake to persons who have committed offenses. It is meant to help them and support them to own up what they have done, but also to come up with negotiations on what kind of sentence should be given to them. I can give you an example of the Kanyamunyu case. It is a very common case where a murder happened, and Kanyamunyu reached out to the family of the deceased person in the northern part of Uganda. They negotiated, and later they came back to court with an agreed sentence, and whatever they agreed on was not brought to the media. We didn't know all the details, but the fact is he committed an offense, he owned it up, he went to the family of the deceased, and they agreed on the sentence. So that is what we call plea bargaining. The world out there has been painted to think that plea bargaining is done forcefully, that inmates are forced to agree on sentences. It is not true. It is a bargain, just like the word is saying. The parties, both the accused person and the complainant, sit down, they agree on a punishment, and the court sanctions exactly what they have agreed on. Or if the court finds that they have agreed on something that is outside the law, the court can advise them to go and renegotiate. I'm using the word court to mean the judicial officer. So when the judicial officer finds that parties have agreed on a sentence that is not within the law, the judicial officer will not automatically sanction it. They will advise them to go back and renegotiate and then come back and reappear before them. Plea bargaining has been designed in such a way that when I'm a judicial officer and I entertain your plea bargaining before me, I may not be the one to hear your case. Because remember now, when you come before me, I have known about the facts that surround the commission of that offense. The best thing to do is to have another judicial officer entertaining that matter in case the bargaining has failed. I want to call upon our people of the Republic of Uganda. I know so many of us have people who have wronged us and they are in prison. We have people who have been wronged and they are home and they are feeling aggrieved. If an accused person who has wronged you reaches out to you, please give them audience listen to them, see what they have to offer, and then negotiate and let them know what your terms are. When we do that, we are first of all promoting our culture as Ugandans, because we used to do it in Uganda, we used to do it in Africa, where people would sit around on a round table and discuss problems and have them resolved. So when we bring on board programs like plea bargaining, we want to support the people who have wronged others and the ones who have been wronged to sit down, negotiate, and first of all accept that someone wronged another. Number two, and also sit down and agree on the nature and kind of punishment that should be given to the person who has wronged the victim or the victim's family. Plea bargaining is one of the methods that we're using as an institution of the judiciary to help us deal with the backlog and the workload that we have in the institution. We want to get away from backlog management to caseload management. I'm using those two terms because I want to be deliberate on this. We have had situations where people come to court and they have committed offenses that are triable by the High Court, and because of the nature of trials in the High Court, which are done on a session basis, a person may take a while before they appear before a judge. And also because the judges are few, it may even take you much longer. So plea bargaining is coming to offer a remedy to this inmate who is sure that they have committed an offense, to go and own it up before the state attorney, and also negotiate with the victim to see what kind of punishment should be given to them, to see if, for instance, they had many offenses against them, if the prosecution can choose to drop one or two against them and maintain the third one. I can give it in form of an example. You may find an accused person who has broken into someone's house, they raped a woman and killed her. Those are like 3 offenses in just one set of facts. So you can negotiate with the victim and say, you know, I killed your mother or your sister after I raped her, but I request that we drop the offense of rape and we go ahead with the one for murder. All those negotiations can be possible, and they can be done when you sit on a round table with the people that you have wronged and still be able to agree on the kind and nature of sentence that should be given to you. But I want to emphasize that plea bargaining is not just a mere handshake for people who have wronged others. It is a mechanism that has been brought in place to support them to own up what they did, to support them move into the court system in time, and also be able to serve the sentences that have been given or accorded to them, and they be able to go back home and catch up with their families. So we want to call upon the people of the Republic of Uganda to embrace ADR as one of the best dispute resolution mechanisms in both criminal and civil matters. Criminal, I said, it is plea bargaining. Civil matters, it is mediation. Let them come to us. We talk to them about the programs. Let them embrace the programs and use them profitably to be able to save on the money that they waste in litigation, to be able to save on the time that they waste on litigation, and be able to go and do other productive things.